Good morning and welcome to Preparing for NC-SARA Policy Changes, Essential Insights for Professional Licensure Programs. My name is Sarah Appel and I'm the Director for the Midwestern region, SARA, M-SARA, and we are going to have with us today Chris Mull from Higher Education Licensure Pros. Sorry, Chris, I always fumble that up. Just before we get started, I just wanted to cover some housekeeping rules. First of all, I want to thank you for joining again. We know that this can be a difficult subject, but we hope it to make it easier for you with this webinar today. We are recording the conversation and we'll post the recording to the website after the presentation today. We welcome questions and please use the Q&A box and we'll do our best to address all those questions that we get. Mary will post a link to the presentation in the chat because we already have the slides from Chris. So that's very handy. Thank you, Chris. And thank you, Mary, for doing that. Upon closing out of today's meeting, we'll have a survey at the end. We ask that you complete that. That helps use your feedback to provide additional webinars and recommend improvements to what we do.
All right, thanks so much, Sarah, for that introduction and for kicking us off here. I am going to introduce myself a little bit more. So as Sarah mentioned, my name's Chris. I'm with Higher Education Licensure Pros. We are a small business that works with colleges and universities around the country on compliance issues related to professional and occupational licensure. I've been doing this work for quite a bit of time, over 15 years now, specializing in these issues within higher education. I got to spend a lot of that time working for a large online university where we built a team that was dedicated to this work. But obviously, most institutions do not have a team, let alone one full-time staff person that you can dedicate to professional occupational licensure. So that's why we created Higher Education Licensure Pros, or as we like to call ourselves, HELP, back in 2020 to help institutions with this complex area of compliance work. So here's the agenda for the next almost hour together today. I'm going to do an overview of what the current requirements are under federal regulation and SARA policy, with an important note on the upcoming SARA policy changes starting July 1st. Then I have some specifics around implementation challenges and considerations that we're going to look at together. I've got a couple of poll questions in this section, so would appreciate your participation in those if you're able. And then I'll briefly touch on our services that we provide to help, but want to spend plenty of time on your questions. So as Sarah mentioned, please do put any questions you have in the Q&A as I go along with the presentation today. We'll try to get to all of those in the last bit of our time together. So before I jump into that overview, just want to make a note that while I am an attorney myself, what I'm providing you today is not legal advice. I do recommend that any of you consult with your own legal counsel when you're making decisions about how to approach this work and specifics around licensure disclosures and certification. All right, let me jump right into the overview. So when we think about professional and occupational licensure compliance for higher education institutions, there's really a few responsibilities that exist under the current federal regulations. And I'm going to get into more detail on each of these here, just setting the stage here with this slide. So the first responsibility is around understanding how your programs satisfy the educational requirements for licensure in other states where you have students enrolling from. The second responsibility under the federal regulations is around certifying. This is actually fairly new still. We're coming up on a year since this became effective July 1st of 2024. But the certify responsibility is connected directly to the program participation agreement, the PPA, which is the contract that each institution signs to participate in the federal financial aid program with the U.S. Department of Education. So this certify responsibility is kind of the biggie here. It means that institutions have to certify through the PPA that your programs do meet the educational requirements for licensure wherever you are enrolling students from, and also where you're specifically advertising or recruiting students for that licensure program. Again, I'm going to get into more details here in a moment on each of these. The third responsibility is around communicating. This one's been in effect since 2020. So institutions have an obligation to disclose information about your licensure programs if they meet the educational requirements or do not meet the educational requirements in certain states and territories, again, where you're enrolling students or recruiting or advertising for the program. And the communication needs to happen through public disclosures, which are typically done on your website, as well as individual direct disclosures, which need to be sent to prospective students or applicants before they enroll in the program, and also to current students, depending on the situation. So again, we'll get into the weeds here in a moment on each of these. But I did want to highlight that SARA policy has similar, but notably one exceptional difference here around the responsibilities. So you'll see SARA policy has that same understanding responsibility. You have to understand how your programs meet educational requirements for licensure in other states and territories. And then you have to disclose that. You need to communicate that if they meet or do not meet. You'll notice the difference is that certify responsibility does not exist under SARA policy. And that becomes important when we talk about the July 1st changes to SARA policy. And that's what I'm going to shift into next here. So you'll see on this slide, I have the current SARA policy that's effective through June 30th. And I've got some language highlighted in orangish here on the slide that the SARA policy basically is saying, look, you need to follow federal regulation, and they've listed the specific subsection of Title IV regulations here that apply. And then these requirements also apply to non-Title IV institutions. Again, this is the current policy. That second paragraph goes on to, kind of add some additional color here that institutions should be making all reasonable efforts to determine if your programs meet licensure requirements. And if you're not able to make a determination, you had certain obligations to disclose the contact information for that state's licensing board and advise your students or applicants that they need to be making that determination themselves. So again, this is existing SARA policy that's been in effect for years, that is through June 30th. But let's talk about the July 1st changes because it is notable here. So you'll see that that second paragraph is now gone completely, and we're left with the first one, which is pretty similar, but they've removed the specific subsection of federal regulations and instead are broadly referencing, institutions must be following those federal requirements for disclosures, that communicating responsibility for your professional licensure programs. Here's the big change. For SARA purposes, these requirements will also apply to non-Title IV institutions and programs. So by adding programs here to the non-Title IV extension, if you will, of SARA policy, it's practically going to mean that for many of you, if you're offering something through your workforce development program, or even something that's just a non-Title IV program at your institution, so maybe it's something that's not very many credits, but it's bundled together and offered, that could now be under the purview for this SARA policy of requiring disclosures, so that communicate responsibility. So Sarah has indicated that this does apply to anything being offered by the institution that would be subject to SARA policy, which kind of shorthand here, very shorthand. If you are applying it to, if you're offering it to students who are located in another state or territory, where they're, probably through online or a hybrid program, if they're going to be located in another state or territory when that learning is occurring, those situations generally are subject to SARA policy because you're offering or operating that under SARA, the State Authorization Reciprocity Agreement. So it's important again to keep in mind we're not just talking about your degree programs or certificate programs. It could really be anything that's being offered through your institution, that again is being offered across state lines where you're going to have the student or the learner located somewhere else at the time that that learning is occurring. Another big trigger for state authorization reciprocity agreement is if you're offering some sort of clinical or field experience in another state, right? So that can often be a way that that's something you're offering, whether it's a full program or some bundle of experiences or training or something, that could fall under SARA, which again would mean if it's something that is subject to SARA policy, if you are offering it in other states under that SARA authorization, then you have to make sure that you will be complying with this new professional and occupational licensure disclosure requirement starting July 1st. And again, welcome questions. So if you have any, excuse me, please do put those in the Q&A feature. So I just wanted to get into a little more detail here on each of these three responsibility areas that I highlighted at a high level under the federal regulations, and then of course the SARA policy regulations for understanding and communicating. So first, understanding, what do I mean by that? This is really subject for any of your licensure programs that you're offering at your institution. It's not specific to online or distance education. It truly does apply to any. And you need to understand if they meet the educational requirements in any other state or territory where you're recruiting, advertising, and enrolling students for that program. So, what's a licensure program to start with? Licensure is really kind of an umbrella term that the Department of Education uses, and Sarah uses, and I'm using today. But it could really be anything that is issued by a state or U.S. territory government that's required for employment in that occupation or profession. So sometimes this will be called certification or endorsement or authorization or registration. The actual terminology is not as important here. The idea behind it is. So again, if it's something that a person who completes your program or your trainings, whatever you're offering, if it's something that they're going to need to earn a license or certification or endorsement, they're going to be issued something by that state or territory in order to be employed. That's what we're talking about when we say licensure. So kind of a test that you can use, to determine which of your programs are licensure programs is what has it been designed to do and what is it being advertised to do. So if it's something that's specifically been designed to result in someone qualifying for that state issued credential, or if it's something that's being advertised to prepare people for that state issued credential that's required for employment, then that would be a licensure program for these purposes. And the reason why this understanding responsibility is so foundational is every state and territory gets to determine which professions and occupations they're going to regulate and how they're going to do so. So licensure truly is a state issue. We have some similarities across states for certain professions and occupations, and oftentimes we'll see that many states or all states have adopted the same licensing examination, for example. But even with those kind of consistencies or similarities, it truly is up to each state to set their own standards for what it takes to qualify for a particular license in that occupation or profession. So it is important to research what each state or territory requires. There could be, and there are differences within the same profession and occupation. So it's important to know exactly, what type of degree they require, what exact courses, if there are specific credits that they're looking for in different subject areas, how many clinical training hours or how many supervised practicum or internship hours that are required, what the details of that supervised experience needs to be. All of those things are very important. And again, they do differ from state to state within each profession or occupation. So once you have that understanding, then it's important, again, to know what your certifying responsibility is. And this is specific to the federal Title IV regulations as they exist today. As I mentioned before, that's through the program participation agreement. So every institution should be able to certify today that any licensure program you're offering does meet the educational requirements where your institution is located and where your distance education students are located at the time of initial enrollment in the licensure program. In this instance, distance education has a specific definition that the US Department of Education is using. It's any student who is taking one or more class online during the first term of enrollment in the licensure program would be considered a distance education student for this purpose. So fairly broad definition here. It's not just about your truly, fully online distance education type programs. It could be a more traditional on-campus program that is offering an online option or a portion of it that could still come into play here with the certify responsibility. One thing I wanted to note is There is this exception that Department of Education has put into place, known as the written attestation. So it's still possible to enroll students, even if they're located somewhere that you can't make this certification. So your program does not meet the educational requirements where that distance education student is located at the time of enrollment. You could still enroll them if they qualify for this exception. And essentially what the exception is, if they're able to indicate that they plan to be licensed and employed in a state or territory where your program does meet the educational requirements, and they attest to this in writing after having an interaction with someone at your institution that explains all of this. If they're able and willing to put that in writing, yes, I'm actually planning to be licensed and seek employment in a meet state, then you can move forward with enrolling them. So again, this is an exception to the certify responsibility, and it allows institutions who choose to engage in this kind of exception process to still enroll students who are located in states or territories where the program does not meet. But the bottom line is, with the certified responsibility, institutions should only be enrolling students if they are located in a meets state or territory. So you have to have made that affirmative determination, yes, our program does meet the educational requirements there, in order to be enrolling students, again, unless this exception is applicable and they go through that process. All right, on to the third responsibility, or the second under SARA policy, is communicating. So again, these are disclosures, both public disclosures and individual direct disclosures that are required in different circumstances. The public disclosures need to now clearly indicate those states and territories where the institutions determined that the program meets educational requirements, and any state or territory where you've determined that the program does not meet educational requirements. The Department of Education has noted that any state or territory where you are advertising for that licensure program or recruiting students, it should be a meets state. So there should not be scenarios where institutions are, advertising to enroll students and it's a does not meet situation. Again, this is coming from Department of Education. Um, Individual direct disclosures are those that are sent directly to prospective students and current students. These are tied to the student's location, which is going to be determined by your institution's own student location policy. So, under the federal Title IV regulations and even under SARA policy, there's not a specific student location policy that applies for these licensure disclosure purposes, but it is up to each institution to have a student location policy in place that you're applying consistently across the institution. So, that student location policy is going to determine where your prospective student is located. If they're located in a state or territory where you've not determined one way or the other about the program, or you've determined it does not meet, then you need to send a written attestation you need to send them a direct disclosure prior to enrollment in the program. So this same group of students now under this new certified responsibility would also need to go through your written attestation exception process in order to actually enroll them. So again, it's this idea of they're located somewhere where your program does not meet. So you need to notify them of that through the direct disclosure. And in order to enroll, you would need to secure that written attestation exception from them. For your current students, you have 14 calendar days to send them a direct disclosure, letting them know that something's changed and now they're located somewhere where your program does not meet. This could be because the student themselves moves to a new location. It could be a state or territory changes something about their licensure requirements, or it could be something changes with your program's curriculum and now it does not satisfy that particular state's educational requirements. So again, institution has 14 calendar days to send this direct disclosure out once you become aware of that does not meet scenario. Very briefly, I just wanted to note another federal responsibility that exists here. This is actually through the Department of Veterans Affairs. So if you are utilizing any sort of VA educational benefits, or I should say if your students are, this is applicable for your institution. And essentially is kind of mirroring what the US Department of Education has put into place as far as the Title IV regulations. with one addition. So additional disclosures are required. These are public disclosures around extra things needed for a student to actually qualify for that license after they finish your program. These are things outside of the scope of your program or what you're offering at your institution. So things like the actual exam itself, that licensing exam that would be required, any sort of experience or training that's done outside of the program. So for a lot of these license types, we do see a certain period of time that they need to be supervised before they can qualify for a full license, for example, or there could be some special work experience or other things that are required in order to qualify for the license. So institutions should be disclosing all of this kind of extra additional requirements that are outside of your program publicly through your websites right now, again, to comply with this VA requirement. The one notable difference here, this applies to where your institution holds state approving agency approval. So typically that's going to be where your main campus or your institution is located. You need to disclose just for that state. So it's not like the Title IV regulations where you're disclosing information potentially for all US states and territories. This is specific to the state where you hold state approving agency approval. All right. So oftentimes I get asked, kind of what are the risks to our institution if we don't comply with these responsibilities, if we don't actually make the public and direct disclosures, or if we're not certifying appropriately, or we don't even understand how our programs meet or don't. So because this is coming under Title IV, federal financial aid, really any and all non-compliance measures are on the table if an institution is not in compliance with the regulations here. So if your institution were to go through an audit and someone finds that you're not actually making the disclosures, you would face different potential penalties. The ultimate one, obviously, being losing the ability to participate in Title IV in those federal student aid programs. Similarly, for SARA, if you're not following SARA policies, the ultimate end result there could be losing your ability to participate in the state authorization reciprocity agreement, which would then mean an institution would have to go about achieving those authorizations to offer programs in other states on an individual state by state basis. So again, if you remember, or if you don't know, SARA basically allows institutions, to have approval through one state portal entity, and not have to send applications and meet requirements and submit fees and all of the other things that go along with seeking approval from the various states and territories where you might be enrolling students from. So losing ability to participate in SARA would create a lot of headaches and hassles, and maybe even limit the ability to enroll students from some states. Another thing to note here is there are some other, federal kind of requirements and other requirements at play. So misrepresentation is a separate federal regulation that does apply here. Essentially, it's requiring all institutions to be providing accurate and truthful information about your programs. Certainly, licensure outcomes is an important piece of that. And then borrower defense to repayment, we have seen over the past a few years actually, but a couple of years in particular, that there have been borrow defense to repayment claims that are being made about licensure. So a student, was led to believe that they would qualify for a license after completing a program, and it turns out that program really doesn't meet the educational requirements, or that there's some other issue there. There have been successful borrower defense to repayment claims that those former students have brought against the institution. So again, important just to make sure you're providing accurate information about your licensure programs and what they do and do not do for students. Another note is accreditors are also kind of enforcing these federal regulations and SARA policy. I've heard from many institutions that when they're going through a reaccreditation process or review, they're being asked to show, where are your public disclosures? We want to see those. What's the process that you're using for those individual direct disclosures to students? So it could be coming from multiple places, not just through a federal Department of Ed audit. And this work is particularly challenging because it's time consuming and it requires a certain level of expertise to do this research. So, as I mentioned before, right, this is a state by state proposition, it's coming through state law. And so, in order to do the research successfully, you really do need to look at the state's laws, their statutes, regulations, rules, and policy to know what those specific educational requirements are. All right, I'm going to shift gears now into the implementation challenges. And as I mentioned, I have some polls. So here's the first poll question. If you would be so kind to participate if you're able. So you can either go to slido.com and type in these numbers 2743625, or scan the QR code that you see on the screen there using your mobile device, and it'll take you directly to this poll. I'm going to pull it, present it here in a moment what the poll actually is. But basically, I'm looking for you to answer which of the listed programs are licensure programs through this poll question. And I'll just wait about 30 seconds here and present the link, and we'll see what is coming in for answers. All right, thank you all that are participating. I'll give just another couple of moments here if you want to weigh in. You can see the results here. So far, all of the above is leading the pack. 74% of you answered that one as the choice. And then we've got several or more of you picking each of the listed licensure programs here, potential licensure programs. So all right. So the answer for this one really is all of the above could be a licensure program. So we're going to kind of go back to those things that I mentioned before. What do you need to think about when you're thinking about licensure programs at your institution? So again, licensure is an umbrella term. So it's related to that state or U.S. territory issued credential that's required for employment in that particular profession or occupation. Maybe called anything else, certification, endorsement, authorization, etc. And the Title IV regulations and SARA policy do not specify which types of programs are licensure programs, right? We don't have a nice list that anyone has put together that you can check off, comparing your programs to. It is up to you as the institution to determine which of your programs are licensure programs in the first place. As a result, we are seeing some differences depending on, what your state requires for employment and maybe what other states do. Somebody's licensure program at one institution may not be considered a licensure program at another for various reasons. But the two keys are, what is it designed to do and what is it advertised to do? So if that program has been designed around a certain set of professional standards, sometimes this includes programmatic or specialized accreditation. Um, it could be linked to a license. So it's important to know exactly what are those curricular standards being used to design and develop that program. Definitely, if a licensing exam is connected in one way or another to the program, so if it's indicating that it's preparing people to sit for this particular exam or it's preparing people to be successful with this exam, it's likely going to be a licensure program. And certainly, if you're reporting licensing exam results to anyone, whether that be an accreditor or someone else, that is likely designed to be a licensure program. And then finally, you might just have expectations that your graduates are going to seek a license for that particular field. This is something probably to be talking about with your program directors or faculty chairs or other academics who are responsible for that program. If their expectations truly are that graduates are going to seek a license, then it's likely a licensure program. The advertising piece, it's not just those very blatant statements where you say, this program is to help you become a registered nurse. Obviously, that's an advertisement that would be directly connected to it being a licensure program, but it's also kind of more generally how the programs are being referenced in your catalog, on your website, and other marketing materials. If there, again, are statements about preparing people for a particular licensing exam or helping, make their efforts in that more successful, probably going to be a licensure program. And then the one that's a little more tricky is claims that are being made about career opportunities. So I've often seen colleges and universities list on their website, a section where it talks about the possible career outcomes related to that program. And there can be listed in those career outcomes professions or occupations that definitely require a license. But maybe it's not really meant to be a licensure program. So again, this one can be a little tricky. I encourage you to take a close look at that career outcome section on your web pages to see what is listed there. And if it's something that would require a license, then likely that program should be on your licensure programs list, or you need to change how you're talking about that particular program so that it's not giving anyone the wrong idea about what those career opportunities are. All right, shifting gears a little bit here. So we often get questions about doing the research itself. As I mentioned, it is very time consuming. It requires a certain level of expertise because it does involve digging in to each state and territory's laws and regulations, their licensing board websites, other information to really try to get an idea of what those educational requirements are. And people often want to know, how do we go about doing this? And is it something that we can take care of once and we're good for good forever or good for a while, or how often do we need to be doing this work? So as I mentioned, it does take time and people power. Specialized accreditation is often an important consideration in licensure requirements, but it's not the be all end all. So we often hear from institutions that, their director of nursing, for example, has said, well, our programs are all CCNE accredited, and we know that our graduates can qualify to sit for the NCLEX, the registered nursing exam. So we can just say that we meet the requirements everywhere, right? No, you can't actually. That's because, again, each state gets to set their own educational requirements for qualifying for that registered nurse license type. And there are some states that have very specific coursework and or clinical experience hours that are required to be within that RN preparation program. So it's not just a matter of relying on specialized accreditation or qualifying for an exam. You do have to dig into the details for each state and territory. And then as far as timing, this is not a one and done type of thing like most compliance work. Regular reviews are going to be required. So we don't have a specific cadence that's dictated by Federal Department of Education or SARA, even for these purposes. But it's something that you'll want to set your own system and process and cadence for at your institution that makes sense. So often we see this as an annual kind of update. Some institutions are able to do it more often than that. I would say be very cautious if you're going too far beyond an annual type of review process because these requirements do change. And so you don't want to have 2, 3, 4-year-old information up on your website. It is likely not going to be accurate anymore. And then you can run into situations around misrepresentation that I mentioned earlier. So finally, documentation, like for most compliance efforts, is very important here. You are going to want to have documentation around what the actual research is. So whoever's doing that for your institution, what are the educational requirements that you found, and then importantly, whoever's comparing your program's curriculum to those educational requirements and ultimately making that meets determination or does not meet determination, you'll want to have some documentation for that that's retained and that you could make available to any Title IV audit or accreditor or your SARA state portal entity, anyone who's going to be asking for that. All right, I have another poll here. Again, if you would please participate if able. This one's around the student location policy. So you'll see in the poll that I've laid out a scenario. I'd like you to determine where is this student located. So if you could go to slido.com, number 4189360, or go ahead and scan the QR code in front of you there on your mobile device. And in just a moment, I will bring up these poll results.
Chris, we have a lot of great questions coming up for the question and answer session at the end. So we're keeping
Great,
track of those and look forward to hearing your answers.
great. All right, so here's the results of the student location poll. Most of you are indicating it depends on the institution's student location policy, and we've got some of you answering some specific states here. So where is the student located? They temporarily live in South Carolina. They're there completing some military training. Their permanent address is Wisconsin, and they're applying to an online program through an Illinois institution. So this will come down to that specific Illinois institution student location policy, how they are determining where this prospective student is located. So those of you who answered, it depends on the institution student location policy, I would say have the best answer here. So let's talk a little bit about the specifics around student location policy, things that you should consider. Again, every institution must have your own student location policy that's going to be used for disclosure purposes as well as that program participation agreement certification purpose. So that student location policy will dictate where that prospective student or applicant or current student is located. And if they're located somewhere where your program does not meet or you haven't determined, that's going to trigger those communicating responsibilities or the necessity to have that written attestation exception in order to enroll them. Um, Things to think about is, how are you going to treat your applicants or prospective students that are relocating to your campus for a face-to-face program versus maybe your fully online students or those that are in hybrid programs. You can treat different populations of students a little differently, again, as long as that is very clear in your student location policy. So sometimes I've seen institutions that do have slightly different ways of determining location for graduate versus undergraduate students. If you are located near a state border, you're going to want to keep that in mind as you are creating and figuring out how to apply your student location policy. How are your commuter students going to be impacted by that? As well as if you have significant international student population, think really clearly about how, when we apply this policy, is it going to impact those international students or your military affiliated students who could be located outside of the US now or located in a different state, like that example that I gave. Here are some actual examples of language that institutions have created for their student location policy. These are only snippets of the policy. That's not the full policy here, but I just wanted to point out some alternatives. So under this one, the institution is noting how they are setting up student location, what they're going to be using. So at the time of the initial enrollment, and then if they're notified by that student of a change in their location, it's going to set this policy in place. The important note here is that the college is indicating, look, this is not going to impact our residency definitions or our residency policy for purposes of tuition. So again, another thing to keep in mind, if that's applicable for your institution, you may need to note that in the policy specifically. But for this particular one, they are going to treat the state or territory where that prospective student is a resident at the time of application and admission. That is what their location is for that prospective student. So again, they could be located in one state, living in, residing in one state now. That's where they're going to treat them as located as for these purposes. For their enrolled students, they have a slightly different definition there. Again, you can designate different populations of students and treat them a little differently in your policy. Here's another example I wanted to throw in, which is different than the first one. So this institution is treating students located wherever they're going to be physically at the time that that semester or term starts, right? So this one goes on to say it's their place of residence, where someone's most likely to find the student, and where the student puts their head down at night. So wherever that's going to be at the time that that term is starting, then that is their student location for purposes of this policy, again, which applies to both the certifier responsibility and disclosures. All right, I have one final poll here. Again, this is for disclosures, so that communicate responsibility. I would like you to let me know if a direct disclosure, so an individual direct disclosure, is required in this scenario. If you could go to slido.com again, and it's number 1174620, or scan the QR code you see on the screen. I will present this one here in just a moment. Once we get through disclosures here, we're going to open the floor up for those questions. So I know Sarah mentioned we've already got some great questions coming into the Q&A, but if you have any you'd like to add there, please do that. Oh, wait, just another 20 seconds here. Let some more people weigh in on this poll if a direct disclosure is required. Thanks to those of you weighing in on this one. So I'm going to share the results here. Is a direct disclosure required if the student currently lives in Nebraska, they're applying to a professional counselor program offered through a North Dakota institution, but they plan to live with their family in Minnesota while they're enrolled? That North Dakota institution has not made a determination about the program for either Nebraska or Minnesota at this point. So is a direct disclosure required? We've got about half of you saying it depends on the student location policy. Another portion, it depends if it's a distance ed program or covered under SARA. And then looks like nobody's saying no. So all of you think that the disclosure may or is very well required here. It just depends on which state, right? So I think the best answer to this question is it does depend on that institution's student location policy. It's also true that an important factor is if this is a distance education program, meaning, would that student primarily be in Minnesota while taking the courses or not? Would they be on campus in North Dakota? So that's an important consideration. But ultimately, it's going to depend on that institution's student location policy, where they are indicating that that prospective student or current student is going to be located, whether or not it's North Dakota or Nebraska or Minnesota. So if it's North Dakota, presumably this is a state where it meets the education requirements. That's where the campus is located. And direct disclosures are not required if it's a meets scenario. So that North Dakota institution does not have an obligation to send out a disclosure saying, yes, we meet the North Dakota requirements for licensure. So it would only be if the student location policy has that person located in Nebraska or Minnesota. So threw in that one, which is a little bit of a tricky one. So again, thanks for answering those if you could. Very quickly, some things to keep in mind for disclosures. So again, technically this does apply to all modalities of your program. It's not just for online and distance education. Practically though, as I just referenced, right, if you meet your own state's requirements, you don't need to disclose for those meets scenarios as far as the direct disclosures. You would need to disclose for your public disclosures that you meet your state's requirements. So for your online or distance ed programs, it is super important to have that understanding that it meets in states where you are enrolling students. Again, you can only enroll for Title IV if they are located in a state or territory where you meet or you go through that written attestation exception process. I think that's all I'm going to say about those because I covered it already. And then as far as help services, so we do offer something called the Bookmark, which is an online database of educational requirements for licensure across all US states and territories. We've got over 80 license types available now. We're continuing to add to that over time. The idea of the Bookmark is really to provide a large shortcut to your work as an institution. So we do that research, digging into the state's laws, boards' websites, communicating with state licensing boards, and compile all of that into one resource that institutions can access in one place. So again, the idea is to save you quite a bit of time and work and frustration in trying to do the research and compile those educational requirements. So if you're interested in that, feel free to reach out to us. You can find us on our website, higheredlicensurepros.com, or if there's anything else with licensure compliance that you might need assistance with, we are happy to talk with you more about that. But I do want to open up the floor to questions because I know we have quite a few good ones that have come in. So,
You do,
Sarah, if
Chris.
you want to kick us
I'll
off.
get it started. And I want to thank the person who entered the 14th question, so we're not stuck on 13. So thank you for that. So, Chris, the first one is if a student is from Florida, applied to attend a face-to-face in your state, do we have to disclose to the student that Florida does not meet the requirement? Our location policy states that the location is based on where the student is located at the time of participating in classes. So for the above question, it would be our state and not Florida.
That's what it sounds like to me. So if your student location policy is indicating that any student who will be relocating to your campus to do that campus-based program that they're located in your states, then you would not have an obligation to disclose. We can talk about what the obligation is under the regulation versus what is most helpful to students, and those can be two different things sometimes. So while you don't have the obligation to disclose under the regulation, you might want to think about, practically, is that student likely to want to be licensed in Florida after they graduate? And in that instance, it would obviously be very helpful information to let that prospective student know.
Thanks. This also deals with students and moving. A student is currently enrolled and moving while in their program, so needs to complete their clinical in another state. Um, is this a scenario that would fall into this guideline?
I would say yes, most likely, with one exception. So you said the word enrolled, which leads me to believe that this is a current student that is moving. And so, what the Federal Department of Ed regulations under Title IV really set the obligation for certifying at the time of initial enrollment in the licensure program. So, meaning if you've got a student who ends up moving at some point while they're enrolled, you don't have that certifying obligation or responsibility. You don't have to worry about if they're located somewhere where it doesn't meet or you haven't determined at that point. Again, as long as they're a current student that's moving, you would have an obligation to still disclose to them. So if they are completing that clinical experience, um, again, it gets a little squishy for me because I'm not sure where if they're physically living in that state or what your student location policy says. If the address is based on physical permanent address or something else, but let's just say that they're moving somewhere else. They're going to physically be somewhere else, and your student location policy says, okay, the student has relocated to this other place to do the clinical experience, and we know our program does not meet there. You would need to disclose to that student, hey, you've moved to this place. Our program does not meet the education requirements, but they can continue in the program. They can continue being enrolled. You don't have any sort of issue with that certify responsibility because that only applies at the time of initial enrollment into the licensure program.
Thanks, Chris. This next question is a wonderful clarification question. If we do not recruit, advertise, or enroll students from Wyoming, for example, does that mean we don't have to disclose about that state?
So, under the current federal regulations that went into effect last year, you do not have a responsibility to publicly disclose, or you wouldn't provide a direct disclosure if no one's enrolling, or from a state. So, if Wyoming is somewhere that you don't do business, essentially, then you do not have an obligation to make a determination. The Department of Education was really clear about that in the commentary that they released with the regulations, that they don't expect every single institution to be making determinations about all 59 US states and territories. It's really about where you're enrolling students from and where you're specifically advertising or recruiting for those programs. I will say, under SARA policy, I have heard that there are different expectations from different state portal entities around this under the SARA policy piece. But it is connected at this point still to the federal responsibilities. And again, the federal responsibilities as they exist now, it's kind of a shift from pre-July 2024. But as they exist now, it's really where you're enrolling, recruiting, or advertising.
Next one is, I'm assuming that these regulations apply to undergraduate higher education. Do these regulations also apply to graduate education too? And my answer to that is also quiz Sarah, is yes, it also applies to graduate students.
Yes, applies to any students at any level. Yes.
Um, are the disclosures re are are the disclosures required for initial licensure, or do renewals of licensures also apply? That's a good one.
Yeah, so under the federal Title IV regulations and SARA policy, it really is about that first license that someone would be trying to apply for and qualify for after completing your program. So if you have like an example I often see in this is either from teacher education or nursing. So if you have some program that you've designed to help, let's just say, elementary education teachers earn some continuing education. So they can apply, some of the courses that they're doing, some of the credits are going to help them renew their teaching license, which they already had. They had that before they came into your program. But what you're offering is something that's going to help them with that continuing education and license renewal process. That does not apply. These regulations are not applicable to that. So again, you want to think about programs or things that you're offering that relate to that kind of first or initial type of license that's required for employment in that profession or occupation. If it has more to do with continuing education or helping someone kind of renew or extend a license that they already held before they came to you, then that's not going to be part of these requirements.
Right. So, excuse me, if we offer non-credit courses that would lead to a licensure, would we need to disclose that?
So if you are a SARA participating institution, which I'm assuming almost all of you are on the webinar today, then yes, starting July 1st, again, with the SARA policy change, you will need to include even non-credit offerings that are subject to SARA policy. So again, I think that's an important consideration. If you have a fully, on your campus training or group of courses, people have to be there in person to do them, they're not going to be doing anything in any other state, then really SARA doesn't come into play, right? Because for SARA, you have to be offering something basically across state lines to students located elsewhere or doing clinicals elsewhere. So keep that in mind. But the short answer is yes, you're going to need to do that starting July 1st.
Thank you. Here's another good one. What about advertising for international students?
Ooh, advertising internationally. So there's nothing in these regulations or the SARA policy that, for licensure purposes at least, speaks about advertising internationally. The advertising piece really comes into play for the U.S. states and territories. So if you are advertising your programs, let's say to folks in Canada, there's nothing under the federal Title IV regulation that kind of speaks to that or places a responsibility on you for that. You will want to make sure in your student location policy that you are addressing how you're going to treat international students. So, where are they going to be located, and have that clearly spelled out. Because, again, depending on the program, the type of program, maybe even if it's a fully on your campus or a hybrid or online, there could be different responsibilities that you're going to have even to those international students, depending on where they're located under your student location policy.
Thanks, Chris. This is probably one of my favorite questions, and I'm totally with this person's question. How is it possible and realistic to know what every state requires? Wonderful question. For example, the big ones are obvious, but say Michigan does not require X, but California does. Many of these are not even made clear on websites or licensing bureaus.
hmm Yeah, I mean, this is the big challenge with this work, really, is finding, understanding what those requirements are in each state and territory, and then comparing your programs. And there could be instances where you don't meet. I mean, that there are going to be instances where your programs don't meet other states because they have very specific coursework or credits or clinical experience requirements that aren't included. So unfortunately, I wish that I could offer like a magic lamp here or something and like grant people three wishes just to get this work done, but there are not a lot of shortcuts. I mean, you really have to dig into each state and territory's requirements, and that means researching the law, comparing that to what's on the licensing board or agency website, often needing to contact or trying to contact that licensing board or agency to get some clarification, which, by the way, licensing boards and agencies are often very short staffed or understaffed, and it can be a challenge to try to communicate with them. And they really have no obligation to you as an out of state institution to give you any sort of review of your curriculum. That's just not something that happens in this process. So the one shortcut that I already mentioned is, help does provide the bookmark, which is an online database where we've done the research essentially for you and compiled it into one place for about 80 different license types.
Thank you, Chris. Um, Most of our programs are compliant and conduct the state-by-state analysis on a regular basis. If just one program is not compliant, would any negative consequences affect the entire university or only that program?
Ooh, that's a great question. So, really, the way that certify responsibility is set up under the federal regulation, it is linked now to your institution's ability to participate in Title IV. So, it's plausible that if there's one licensure program that an institution's kind of been ignoring and they're not making determinations or not paying attention to where students are enrolling from, that could actually cause a scenario where your entire institution could lose eligibility to participate in Title IV. So it's really could be a very big consequence for just having one program that's not in compliance here.
Thank you. Um, we struggle with licenses that are optional for employment. For example, an accountancy curriculum might be designed for licensure, but not all grads want to seek being a CPA. So does grad intention for licensure matter for these optional licensures?
Yeah, accounting's always a sticky wicket here. And, I've seen institutions basically split 50-50 on this. Some of them are considering accounting programs to be licensure programs, and some are not. So, again, we kind of go back to what's it designed to do and what's it being advertised to do. And again, those things could be different from institution to institution. So, if your accounting programs have been designed to prepare graduates for licensure, if you're talking about qualifying to sit for the CPA exam or preparing to sit for the exam, that kind of skews it a little bit more towards being a licensure program. It is interesting because accounting is one of those fields where you can be an accountant and not be a CPA. But to be a CPA, you need to be licensed in every state and territory. So again, the advertising, the description of the program is very important. If it's all referenced around CPA and that's what you're talking about, then I would say it's a licensure program. If it's more general about accounting, then maybe it's not a licensure program. So I know this is a tough one. It's not cut and dried, but it really does depend on how your institution's designed it and how you are advertising it.
Yeah. Thank you, Chris. We are unfortunately out of time. Again, I want to thank everyone who joined us today. I especially want to thank Chris Mall for returning to do another wonderful webinar for us. We have records of your chat or your Q&A, and we'll look through those and try to perhaps get those answers to you. And again, please complete our survey. Chris, any final words for our group?
I would just say, with everything changing in higher education and the Department of Education today, just stay on top of these things. I know MEC does a great job of keeping everyone informed. So never hesitate to reach out to me either if you have questions about licensure. I love this stuff. This is what I talk about all the time. So Happy to be here. Thank you.
All right. And we're happy that you love it. So that's great. So thank you, everyone, again. Have a great day and be safe. Bye-bye.